extra difficult being on the road. But my baby's name is Sophia. As I said, she's 18 months old. And this is the primary reason I'm running for this office. There's no question that there's deep concern around the state and indeed around the country of where we are heading. And the Attorney General's office is one of the most unique offices where I can work on from day one the two things that I think families and our communities care about most. And that is our security and our prosperity. And I believe my background, which I'm sure will go in, hopefully in the debate at great length, but someone that came out of Georgetown Law School and was a Navy JAG officer, and someone that's been a prosecutor, someone that's been a legal advisor in major circumstances, including overseas in Iraq, someone that was nominated to be a professor of law at the U.S. Naval Academy, and finally someone who has a lot of private sector legal experience as well. This broad range of legal experience, I believe, makes me the most qualified for this job. And my vision, which I've laid out this year, is something that hopefully we'll talk about today. But we need a vibrant, active office, and we need an Attorney General who's going to work hard every single day, something I've done every day of my adult life. I've done nothing but succeed and accomplish the task I've set out to do. And Nevada needs that Attorney General this year, and I look forward to being it. Thank you.
Well, thank you. I'm thrilled to be here, and I want to thank the Press Association, who has always historically recognized the importance of this debate. I think highlighted by the fact that they scheduled us to immediately conflict with college football and Saturday morning cartoons this morning. My daughters were going to come this morning, but it conflicted with a new episode of Dog with a Blog, and so I think that puts it all in perspective. But you know, what I've loved about being Secretary of State and now campaigning for Attorney General is that both of these jobs are essentially about solving problems. I didn't get into public service to get involved in partisan disputes and ideological disputes. I got in this to make a difference for Nevadans. And we have real problems that need to be solved by an Attorney General in the state. We have scam artists who come to our community, who try to prey upon the aging population, to try to rip these retirees off of everything that they've saved so hard in their lives to prepare for their retirement. We have sexual predators who come to our community and refuse to come into compliance with our registration laws so that the cops can keep track of where they are, to keep them from reoffending and abusing our kids. And since we're living in a digital era, we have real tension between the interests of privacy of the individual and the private sector, and making sure that law enforcement uses the data that they need in order to catch the bad guys. We need an Attorney General who understands that balance and can make sure that we maintain personal privacy, that we make sure that the private sector has the information that they need to thrive, and that law enforcement, at the end of the day, has the means to get the information they need to catch the bad guys. I have experience solving real problems. First, as a criminal prosecutor, working on the front lines, trying and convicting everything from murderers to child molesters, working on the front lines to keeping our community safe. Then as Secretary of State, as Chief Elections Officer, cracking down on election law offenses and imposing record fines and penalties to members of both parties. And then as head of the Securities Division, making sure that we go after those scam artists, imposing lengthy prison sentences and recovering millions of dollars in restitution. And when times were tough in my office, I'm proud of the actions that we put forward. Cutting our office budget by over 29%, while at the same time adding additional services, increasing revenue to the state so that we can fund our essential services, and giving back part of my salary so that it could fund the general fund. Like many of you in this room, I love this state. I was born and raised here. Born here in Las Vegas, raised for the most part in northern Nevada. Leslie and I are raising our 3 kids up in northern Nevada, and I believe the Attorney General's office is poised to make a real difference in this state. That's why over 4,000 cops and prosecutors across this state have endorsed my campaign, because they know that I'm putting Nevadans not personal politics or ideological disputes first. And that's why I'm asking for the public support. Thank you.
All right. My name is Steve Sebelius, and I too am running for Attorney General. No, I was going to do it right up until Adam said it. You have to work hard every day, and then I said this is not the job. I want to thank Barry, of course, for inviting me to do this again, and assure all you Press Association members I have seen Barry late at night in the legislature, working the halls. He does not gold brick at all. So thank him for all he does up at the legislature to help the association. And I want to thank both candidates for being willing to come out and do this and miss those cartoons. I'll personally be watching those cartoons actually on my phone while they answer questions, so I won't miss out on anything. Normally what I do to start this off is I ask each candidate if they could name all of the 5 distinct freedoms that are encompassed in the First Amendment, but I am reasonably confident by now that this trick has been well known, and I think both are prepared for that. So we're going to go to the Fifth Amendment this year. No. We're going to start with some questions that are particular of interest to the Press Association and open government, open records, and we'll move on to some questions of a more general nature. So one thing that I've noticed, and this has become a pretty significant problem for access to public documents, is that when it comes to requests for public records, government agencies typically tell news organizations that there's hefty fees just to gather the information so it can be examined by a requester, to say nothing of copying. So there was one television station in town I'm familiar with that made a request of the Clark County School District for records, was presented with a bill for $11,000 just to see the records, not necessarily to inspect them. So my question is 2 parts. First, do you think those fees are legal to charge? And secondly, do you think they constitute a barrier to examining those public records? Adam, why don't you go first, and then Ross, you can take it, and then we'll switch the order next time.
It was my understanding that our openings were 2 minutes, so hopefully you let me steal back a few minutes here.
It seemed
sometime during the debate.
like just seconds flew by.
I'm sure.
We were both talking.
You know, I think that transparency is one of the most important issues we face as a state and as a community. I think one thing the Press Association does an exceptionally good job is holding government's feet to the fire. Elected officials are representative of the people, and our government is of the people. And there's nothing more sacred than making sure that backroom deals aren't happening, and, you know, that government is not simply picking winners and choosers. Transparency is absolutely essential. The open meeting law that, again, that the Press Association fights so hard for is crucial. And, you know, I will say that I will certainly fight as an Attorney General to make sure that the Attorney General's office is vigorously reviewing these open meeting requests and making sure that that's a priority. As specific to your law, I'm not really sure. But I can say that I'm very concerned that, you know, when you have my opponent who's been in office for 8 years and has shown a pattern, I believe a reckless pattern of taking gifts, up to $70,000 in gifts he's taken as an elected official. You know, this is the kind of thing that concerns me, and I think it really makes people wonder whether their government is working for them or whether their government works for special interests. And transparency is the absolute key to make sure people have faith in their government.
But just to follow up, so you're not sure if those, as far as you're concerned, those fees that they charge are legal or not legal?
I'm not sure.
Okay.
Those fees are not legal, to set the record straight. And I have history with this. And this is an important issue. Maintaining transparency in government is one of the most important things that we can do to encourage the public's faith in our government. And the Fourth Estate and the press are an essential component of that. So we have to make sure that they get the records that they need, which are truly public records. And I have a history of doing that. I champion transparency more so than any other Secretary of State in history because I recognize that importance. There is actually a statute that was passed last legislative session that outlined a fee structure and how much agencies are allowed to charge in order to be able to obtain these records. It didn't extend to local governments. I think we've got to go back to the legislature and make it extend to local governments. Individual agencies are also able to set their own policy. And I have experience of showing the cooperation that we're willing to undertake as Secretary of State and how I'll serve as Attorney General, because we have a policy in our office that if any member of the press requests any of our records, they're not charged for them. And we do that as in as quick a time frame as we possibly can. My opponent mentioned the gifts. I'm not sure that fit with the question, so but let me address that anyhow. Because the entire reason that that's out there is because I went above and beyond and disclosed these items, which many other elected officials in this state aren't doing. And so that's out there as part of the public record because I wanted the public, the press, anybody that wants to look at it to have the right to know. And he has completely mischaracterized those gifts and packed them upon a bunch of lies. And I'd be happy to address it in a question that actually fits, but this question was actually about how you deal with public records. I have a track record and experience in turning those over. And in fact, when my opponent and these dark money groups came into my office and requested thousands of pages of information, maybe every piece of paper that we had ever produced, we turned them over as quickly as we possibly could. Because in the interest of transparency, those are public documents. And I want the public to be able to evaluate those documents to see if there's anything in those documents that would bear on whether or not I'd be qualified to become an Attorney General. That's the stance I've taken as Secretary of State. I'll take that same stance as Attorney General.
And so just to clarify, you think we ought to go back to the legislature and set a fee schedule, not just for the copying of public records, but also for the gathering of whatever records in response to the public records request?
Absolutely. And that's already set within state law for executive agencies. For whatever reason, they didn't extend it to local governments. So the example that you mentioned didn't apply because that was a local government. And they should be held to the exact same standard. And I can tell you, as somebody who's had probably more records requests than anybody in the state, with these out-of-state groups coming in and want every piece of paper, it is a burden. It shuts down the office to try to go and collect every piece of paper that's ever been produced and do that in a reasonable time frame. But I was happy to do it. And it's now part of the public record because my office saw that as a priority. We put that out there and disclosed absolutely everything.
We'll switch the order, and Mr. Miller, you'll get this question first. The fees that are involved in copying public records are still fairly high. NRS 239.052 specifies a fee charge for making a copy of a public record, quote, must not exceed the actual cost to the government agency to provide the copy of the public record unless a specific statute or regulation sets a fee that the government entity must charge for the copy, end quote. Do you think the law ought to be changed to set a maximum fee, say 5 or 10 cents a page, as was proposed by Senator Segerbloom in a draft of his legislation, or not?
No, I think we've absolutely got to set a standard in place that makes it reasonable and work with all the stakeholders to figure out what that is. I can tell you, after having gone through this the last couple of years and dealing with these out-of-state groups that have requested thousands of pages from my office, there's a real cost to it. And it requires a lot of personnel to drop everything that they're doing, to set aside the priorities that I came into this office to try to accomplish so that we can fulfill these records requests. And so we don't want to have a standard in place that allows for people to just shut down government by asking for these pieces of papers and just not, and only charging a nominal fee. It's got to be reasonable and there's got to be a balance. But I think the current system works. It can always be revised and improved, so we should take another look at that.
Well, as I stated initially, transparency is essential for government, and there's a reason we have these open meetings laws. And I'm happy to roll up my sleeves, as I did in the military. I've done it every day of my working life. I've always gotten these problems resolved. I believe this is why I have the endorsement of the grand majority of elected sheriffs and DAs in this state. These are DAs that I went around the state over and over and earned these endorsements because I know I'm going to work hard and I'm going to get results in this office, something that I've always done. And so, you know, all I can pledge to you on this specific, very specific issue, I commend you for it, is, you know, we'll do what we can. And governments need to make sure their records are available to the public. That's a very important function.
But a limit
I understand the fees.
5 or 10 cents a page?
I just don't know what's a reasonable fee, and I don't want to speak out of turn unless I've really reviewed it and what these things are costs and what kind of burden they currently are.
Okay, well, Mr. Laxalt, the next question goes to you first. What penalties, if any, do you think ought to be added to NRS 239.0107 for government entities that fail to produce public records within the 5 business days established by law, or provide a written explanation of why they cannot do so? Do you think there ought to be a penalty if the government misses that deadline when a request is made by a member of the public or a member of the press?
Well, you know, currently, if these open meetings laws are not followed, there's misdemeanor, there's both civil and criminal sanctions available, and I'm not positive how this applies when they're 5 days late, but it's something that we should look into. I believe it's a little bit more of a policy question for our legislature to figure out, you know, whether they want to add a stiffer punishment onto beating or losing this 5-day deadline.
Well, but you're talking about civil and criminal penalties and open meeting law.
Correct.
This is the public records law I'm talking about.
I understand.
So there's no.
I'm just trying to make the analogy that I know it exists for those, and I'm not.
Do you think there should be like a misdemeanor penalty for violating that law?
I think we'd have to look at it.
Okay. Mr. Miller, what do you think?
Look, my opponent has clearly demonstrated that he doesn't understand the difference between the open meeting law and public records, and that's key. I do. And so here's the way I think we should address public records and failure to fulfill those requirements. One, we've got to put more clarity in the law. We don't have that now. We don't even have a statutory definition of what constitutes a public record. And so it's not clear to the public as to which records have to be kept. Two, we have to educate these agencies as to how you fulfill these public records. And then three, we've got to have stiff enforcement. That means giving the Attorney General's office greater ability to get in there, issue subpoenas, conduct investigations, and hold individuals accountable if they're not meeting the requirements. That can include civil or criminal penalties if it's a willful violation. I think that's the only way to address this, to make sure that we get that up in front of the public. I hear my opponent, talking about the fact that if he takes office, he's going to make this a priority. But since he mentioned the gifts, let me just suggest to you, he's been sitting on military records and his personnel file suggesting in numerous media reports that he didn't have them. It turns out he did. He'd said there was nothing but glowing reviews in his personnel file. That wasn't the case. And now all of a sudden he comes forward, cherry picks a couple of military records. If he's so committed to putting this information in the public so that the public can make an informed decision, why doesn't he turn those over? And the fact that he hasn't turned those over, isn't that telling? We don't know who he is, what he stands for. We're only 45 days away from the election. If he's so committed to putting public records out there so that the public can make an informed decision, I encourage him to push those records out there so that we can make an informed decision about whether or not he's qualified.
All right, now we will turn to the open meeting law. Under the open meeting law, as Mr. Laxalt noted, there is a penalty that if a public official is found to have violated the open meeting law intentionally, he or she can be removed from office in a proceeding that the Attorney General could bring. First now to Mr. Miller, why do we never see, although notwithstanding numerous reports of violations of the open meeting law, why do we never see a prosecution initiated on that basis?
We need more aggressive enforcement. And I commend the current Attorney General for taking steps to get us there. We saw only a couple of weeks ago, she stepped in and took an aggressive approach with the Washoe County School Board, initiating an investigation, ultimately holding them accountable and imposing a fine. That didn't happen by accident. That happened because she worked with the legislature to try to enhance the tools that the Attorney General's office has in order to be able to conduct those investigations. going to the legislature and asking for subpoena power. So when they got a complaint about what had taken place up there, they went and conducted interviews, and they issued subpoenas so that they could get a hold of text messages, get a hold of cell phone records to determine whether or not a violation took place. It's imperative that we do that we hold these individuals accountable when they refuse to comply with the open meeting law and run government in a transparent manner. I've got a history as Secretary of State that I can point to of doing just that, of cracking down on members of both parties and holding these individuals accountable. These are tough deals. You have to get in there and try to take enforcement actions against your colleagues. Sometimes these people are your friends, can be members of your own party, members of the other party who are going to be accused of playing partisan politics. I've got a long track record of doing that, going after organizations that were aligned with the Democratic Party, imposing record fines in the last gubernatorial campaign on both sides. And so when it comes time to enforce the open meeting law, I intend to be very aggressive, and I will uphold the law in as aggressive manner as possible.
Mr. Laxalt, what do you think? Should there be prosecutions if somebody violates the open meeting law to remove them from office?
You know, first I'd like to address to Ross who I am and what I stand for. And, you know, I think it's rather appalling that he would ask that question. I'm someone that out of law school decided to volunteer to serve my country. I went to Georgetown Law School. I could have gone to a DA's office like Ross did and start priming my political career and walk my way up the ladder. Everyone knows the DA's, assistant DA's office is your entree into politics, but that's not what I did. I decided to join the U.S. Navy. I decided to join the U.S. Navy at a time when 15% of people were being accepted into the JAG Corps. And of all of us that were accepted, we knew there was a huge chance we were going to be deployed to a war zone. So what I stand for is service, and I know he can't understand how anyone would ever challenge him for this office. I understand that. I hear that. I've heard that since day one. But I'm here because I want to serve this state. I want to make a difference. I have a legacy in our family that is of service. Service to make this state, since the 1850s and 60s, we have done in every industry in this state. We've made Nevada a better place. That's why I'm serving. You know, I could have run for any office on the planet. I'm running for this office against this guy because I think I'm going to do a better job.
In that service, then, if you manage to get into this office, do you think we ought to prosecute and remove from office violators of the open meeting?
You know, I'm restating what I said initially. I think there's no more sacred trust to government to make sure that people have access to what's happening behind the curtain. And these laws make sure that you cannot have deals made by a county commission or a city council behind closed doors. They're there for a reason, and we've worked very hard to make sure they're in place. The Attorney General has a prominent role in enforcing this and indeed investigating, like Ross suggested with the Washoe County situation. We need to be fast, we need to be reactive, we need to be willing to investigate and issue subpoenas. I agree with that. And you know, if the offense is blatant enough, certainly we need to look at criminal punishment.
And so, back to you, Mr. Miller. Don't you think that if one or two public officials were removed for violating this, we'd see fewer violations?
Look, I said this from day one as Secretary of State. When I campaigned on a platform of ensuring that I would come in and crack down on election law violations. And I use this as an analogy because those kind of violations had gone on for too long, completely ignored. And I promised to come down and crack down on it. First thing I did was form the Election Integrity Task Force, a multi-jurisdictional task force that involved law enforcement representatives from every agency in the state and federal officials. And we held a press conference and we said, look, we're not going to stand for these kind of violations moving forward. And we're going to go after them aggressively. We cracked down on Acorn. Even though that was a Democratic organization, I led the investigation that ultimately resulted in a raid with the only that we are the only state that charged that organization with criminal penalties for which they were ultimately convicted. That sent a strong deterrent effect to organizations throughout the country as a battleground state. You can't come out here to Nevada. This isn't the old Wild West and just run over us without any fear that we're going to step in and go be aggressive in our prosecution. We didn't see those kind of activities in future presidential elections. That's the same thing we need to do with these kind of violations. If you step up where you see an egregious violation, hold those individuals accountable, go after them for criminal or civil prosecution, and potentially removing them from office in the most egregious cases, you won't see that kind of activity happen in the future. Deterrence has that type of effect. That's what I'll do as Attorney General.
Mr. Laxalt, this one first to you. There is a deputy in the Attorney General's office assigned specifically to police open meeting law violations. If elected, do you think you would assign a deputy to police violations of the public records law and give the public some person to turn to if they feel that they've asked for a record and been improperly denied?
Yeah, I'm aware that there is someone permanently assigned to that, and someone that we do need to get moving, get I believe, working more effectively to track our meetings and make sure that every time these are happening, that the rules are being followed. It seems to me that it could be a natural fit to whether we add an additional deputy or make someone dual-hatted, that we could do this. And you know, there's 200 lawyers in the AG's office, over 300 staff members combined, and so you know, you get in there, you got to prioritize and make sure that the job's getting done on all fronts. And there's certainly a lot of areas where the job just isn't getting done right now.
Would that be a priority if you're elected?
It would be a priority. I mean, I think in we keep talking about both of these situations, and it is one of the most important reasons for me to run for office is to represent the people and make sure that this grand frustration that exists around the state, that government is no longer for the people. The government is ran by a handful of people that feel entitled to office, and they feel like they get to serve just because they get to serve, because they've been there. This is the kind of thing that I think that the public is totally frustrated with. They don't think that our elected officials are actually accountable. And this is one of the main reasons I'm running, and it's one of the main reasons, again, why I look forward to being a partner of Governor Sandoval, while we have these incredible endorsements from the elected DAs and sheriffs. You know, my military background, when I swore the oath to be a naval officer and a JAG officer, you are the most nonpartisan enforcer of the law that you can imagine. There is no politics in the military. And this is what I bring to this office. I look forward to fighting for Nevadans.
Mr. Miller, what do you think? Deputy assigned to police public records violations?
We should absolutely have a deputy that would be assigned to police public records violations. And not only that, we should lend investigative resources to make sure that they're following suit. This poses, acknowledge that this poses a bit of a conflict because the Attorney General is also responsible for representing and defending all of those agencies. But you can impose a Chinese wall. They do it repeatedly in all different kinds of contexts. And so what we need is somebody for the public to be able to go to. An investigator with the AG's office that can go to that agency and say, here's the request, why hasn't it been fulfilled on time? Because otherwise, they're stuck having to go to the courts. And that's not a realistic remedy for them. They need somebody immediately that they can turn to, that can investigate, try to get an answer, and push back. And I think if we do that, we'll see these records fulfilled in a more timely manner, which ultimately will give the public access to the information that they need on a timely basis.
We'll move now to some of the more general questions. Twice during her tenure, the current Attorney General, Catherine Cortez Masto, refused a direct request from the governor to initiate litigation, notwithstanding the fact that the law says that the Attorney General must initiate litigation when the governor so directs. Specifically on the Affordable Care Act, Governor Jim Gibbons asked Attorney General Masto to join the lawsuit against the federal government that had been filed by about 25 states seeking to overturn the Affordable Care Act. The Attorney General refused, saying first that it was Nevada had no cognizable interests that were different from the other states, and so they didn't need to join, and second, that it was frivolous litigation. This question first to Mr. Miller. Did you agree with her decision, and would you have done the same thing in that circumstance?
It's hard to address what I would have done hypothetically without the benefit attorney-client privilege discussions that the Attorney General at that time had with the governor. I know from reading her public statements that what she indicated was that she conducted a thorough review of the law, that the governor had directed her per that statute, which makes it very clear that if the governor directs the Attorney General to file a lawsuit or defend against a lawsuit, the Attorney General shall file that lawsuit. She conducted a thorough review. She talked to the other states, the 17 to 25 of those other states that had joined in on that lawsuit to get an understanding of their legal reasoning. And she cited to an ethics statute that says, I have an obligation to only bring cases where I think there's a good faith basis to win that lawsuit. Obviously, with hindsight, we know that with a split decision, there was at least some legal basis to challenge the Affordable Care Act. What I can tell you moving forward is that that statute to me is entirely clear. And that statute says, if directed by the governor to file a lawsuit, that the Attorney General has the mandate to do that. I've got a strong working relationship with the governor. I intend on having that relationship with him moving forward. If these issues come up in the future where I'm directed to file a lawsuit, I intend to consult with him about any legal issues that are out there and ultimately work with him to try to take his lead.
So you would not, you don't think that the ethics statute that the Attorney General cited trumps the statute that says the Attorney General shall initiate litigation, do you?
Again, it's tough to address hypotheticals. I mean, obviously there could be some situations, not very often. The bottom line for me is that the statute makes very clear that I am directed. If the governor so directs, I'm required to file a lawsuit. And only in the rarest of circumstances where I truly believed that there was no legal basis to do it. And I don't anticipate that happening, but if that did happen, there's other avenues to bring in an outside counsel. But I would not anticipate that happening.
Mr. Laxalt, what do you think? Do you agree with the Attorney General's refusal in that case, and what would you do in that circumstance?
You know, I really don't think it's that hypothetical at all. You guys followed Obamacare every day as that was coming down the pipe. There were a lot of attorney generals that had filed the lawsuit. The governor wanted this attorney general to file the lawsuit, and the lawsuit should have been filed. You know, the notion that there was a no good faith argument obviously falls on its face, given that it went to the Supreme Court and was a very, very split decision in many different ways, actually. So absolutely, it's the job of the Attorney General to file a lawsuit. If the governor orders it, that's the law. And it's important that the Attorney General enforces the law in a non-political way. If whether I like a law or don't like a law should never enter into my equation. People are concerned about what's happening to the rule of law out there, and they think that whether it's judges or now this new trend of attorneys general, they're making the law hyper-political. And it's something that I pledge to not do. There are going to be laws that I personally don't agree with, that if it's my job to enforce them, I will enforce them. I do want to say that, you know, Obamacare is the first such situation, but you know, the importance of the Attorney General's office and being willing to use this office to work with the governor to protect our state from a federal regulation that can decimate our jobs and our economy is essential. Not only should NASDA file that lawsuit, we need an Attorney General that is going to be looking for opportunities to protect our economic vitality. Obamacare is one. I've talked to a number of you and on the road about sage grouse being the next major one, where we need to have an AG that's going to be willing to file that lawsuit, that's going to be willing to try to hold up the listing of that sage grouse, because what that will do, it may sound esoteric to some people, but it is going to cost lots and lots of jobs. The thing that the governor works every day, as we all know from this past week with his advertisement, he has added so many jobs to the state, working hard every day. I look forward to being his partner as Attorney General, working for other avenues to make sure we are adding jobs to this state.
Just to clarify, can you foresee any circumstance where you would not file a lawsuit if the governor directed you to do that?
No, I cannot, off the top of my head.
think the Attorney General, and this is first to you, Mr. Laxalt, do you think the Attorney General is obligated to defend every law passed by the legislature? Are there any exceptions? Are there any laws that you think the legislature passed that you would not defend it on ethical, legal, or any other grounds?
I mean, if there's something that I think is unconstitutional, either by our state or U.S. Constitution, that's a legal analysis that needs to go into that. But, last thing I want to do is send a signal that I'm going to be looking for avenues to not enforce the law. I think we need to send the opposite signal, that Attorney General needs to be relied on to enforce the law, to be apolitical, and make sure that people can rely on that person to just be that enforcer of the law. And if there are certain circumstances where it's a heavy law enforcement issue, and I feel like with the sheriffs and DAs and other law enforcement around the state, that it's something that's making our community less safe, something that's really hurting the most vulnerable in our society, then you take an active role and you use one of your bill drafts and try to change it. But I don't think it's appropriate to just use the office and kind of manipulate the law to make sure it fits what you think it should be.
Well, you said something interesting at the very beginning. If there was a law that you thought was unconstitutional, now as you know, all the laws passed by the legislature presumptively are constitutional until they're found otherwise by a court. But if they passed something you really thought was unconstitutional, you would go to the district court, the Ninth Circuit, you would defend it.
No, like I said, if it was something that I felt somehow was unconstitutional, I'd have to very much evaluate that and see whether or not there was a challenge that needed to be made to it.
Okay. Mr. Miller, what do you think? Are you obligated to defend every law the legislature passes?
The Attorney General is the state's top attorney. And that individual has to be a true leader. You have to look at every issue with a deliberative mindset, to look at all the constitutional issues that may be out there. That there obviously, as you mentioned, a presumption that that law may be constitutional. But you can certainly envision statutes that are put in place that would be clearly unconstitutional. And if faced with those, I wouldn't defend those. If the legislature passed a law to require somebody to wear the Star of David, or as we had heard suggested from one legislator that if his constituents wanted, he would reinstitute